Today, I'm wearing two hats. Isn't exciting? One of them is on the Shared Learning Forum committee and on the DSTO facilitator, but today Wendy Leaver and I are presenting on sexual assault consent in the law. And on this particular lovely project, I'm part of this amazing team at Montage Support Services that supports victims of domestic human trafficking with IDD. And we are presenting this really, really important topic in education because this is something that guides us, frustrates us, but it's a part of our reality in working with individuals with IDD when it comes to the law. And we want to share all of our greatness with you today around some of the things that go on, obviously the realities of the law, realities of the work we do, and maybe some insight and tips for you to understand more about how we navigate the system of supporting individuals who may come across the law or obviously are involved in sexual assault and the concepts of consent. I will introduce myself quickly. You can read this later, but very quickly, I'm not going to read my whole thing, but I am going to read Wendy's. But just to let you know that I've been in the DS services for about 25 years, and one of my passions has always been sexual health. And I've been affiliated with the relationship group through that whole time, and I'm a member of the service team that supports victims of domestic human trafficking. And I really focus on empowering sex esteem. And I do many trainings from one-on-one to staff, all rights-based. And what I really love for you guys to walk away from today is understanding the importance of sexual health. And if you need someone to talk to about that, you can reach out to myself. But I am here today to present with the great Wendy Leaver, who I can call a mentor and friend and someone who is on our domestic human trafficking team. She's really guided us with her expertise and it's been incredibly helpful. Wendy Leaver is a retired detective of the Toronto Police Services Sex Crimes Unit, where she investigated sexual assault cases for 20 years. She was instrumental in the development of the Special Victims Unit in 2005, which investigates sexual assaults against sex workers. This was the first investigative unit in Canada solely dedicated to working with sex workers who have been sexually assaulted while involved in the sex trade. She's an accomplished lecturer in respects of investigations involving sexual assaults, child abuse, victim issues, and pedophiles. Wendy is also a volunteer for the past 18 years for the Circles of Support, a volunteer-run initiative supported by Corrections Canada that has proven to be an effective method of dealing with high-risk, high-need sexual offenders released at warrant expiry in communities across Canada. Wendy has worked extensively with sex workers and agencies supporting them. She is presently working with the Women's Initiative Committee, Rotary Club of Toronto, to develop a safe house for victims of domestic and international human trafficking, opened in November 2016. I'm sure that she's done many great things for sure. These are just a small highlight of what Wendy and how lucky we are to have her on our team with us today. So Wendy, I'm going to pass over the baton to you and let you get started.
Great. Good morning. Thank you very much for everybody attending. My involvement with Montage has been eye-opening, having investigated sexual assaults for 20 years. To be honest with you, I had very few women with mental disabilities during those 20 years and can understand the reasons why. Last year, I've been able to do research, taking a look at every article I could get my hands on or report or whatever in relation to women with developmental disabilities that are sexually assaulted and what happens to them and what's needed. So that's been eye-opening for me. We're going to take a look at the criminal code and the consent issues today. I'm going to give you a very brief overview due to the time. But I think at the end, we've come up, which we think is a possible solution, not a solution. Maybe, I don't know, maybe a possible solution for dealing with women with disabilities and the ability for their voices to be heard with possibly not dragging them through a court system. And in some cases, remaining their anonymity and giving the information. Prior to 1982, the rape law definition was man having carnal knowledge of a woman who was not his wife. Without her consent, carnal knowledge was complete at the point of penetration. What that means, in order to lay that charge, penetration had to occur. The sentence for that was a pretty good sentence, life in prison or being whipped. Okay, attempt rape was 10 years in jail or being whipped, not ripped, whipped. From 1912 to 1982, the criminal code was established there, had approximately 28 offenses covering everything from seduction of girls between the age of 12 to 16 to buggery, indecent acts of gross indecency, indecent assault female, indecent assault male. The challenges in a lot of these cases up till 1982 was marriage was a defense. So if you were married, no go, no possibility of laying a charge against your spouse. Cooperation was necessary. It was absolutely necessary to have a victim that could back you up in your evidence, corroborate what had happened to you. Burden of the proof at that time to prove that the victim was not a chaste character. So what the accused would do is just for the defense, bring in 3 or 4 other males who would attest to having sexual activity, sexual intercourse with a victim, and that was it. The case was gone. Honest belief was a valid argument. Well, I didn't know. I didn't know she didn't want to do this. I thought she consented. I really believed, etc. And then again, the case would go down the drain. Myths. Certain type of women are unrapeable. Occupations make some women unworthy of belief. For goodness sake, if you're a sex worker and you're sexually assaulted, that's just part of the job, okay? It's basically a job injury as far as they were concerned. If you're a sex worker, you should be expected to be sexually assaulted. And many years ago, when I was able to start the part of the sex crimes unit, the special victims unit, for the first time in Canada, we had people devoted to nothing but investigating sexual assaults against sex workers. And when we started to arrest the individuals, we'd get comments like, but she's a hoe, she's a prostitute. Yeah, but the, sort of the conditions you have and the deal you made with her was for sex, not to kick her about, not to knock her teeth out. I had cases where women had their feet just torn to bits by razor blades. And years ago, what do you expect? This is part of your job. Drug use during that time was relevant to the issue of credibility as to consent. You're a drug user. You must have given consent. Take a look at your character. This one, women are emotional. So in other words, if the investigator or if the police who were initially arrived on the scene of the assault, of the complaint, and their evidence was when the defense would ask them, well, what state was the victim in? She was seated on the couch. She was very quiet. They expected, and so did the courts, you'd be hysterical and physically upset and not able to remain cool. I mean, we now know that if any of us has gone through a traumatic situation, and if you stop and think some trauma you suffered, how did you respond? Maybe you just were very quiet. Maybe you were screaming and yelling and crying. Maybe you went out and got drunk, etc. There's no one specific way. We had to do a lot of training with the police during that time to explain. And the courts, I guess, eventually caught on. Also, very important before 1982 is you had to report immediately to someone to add to your credibility. Okay, and if you didn't, well, why would you take 6 months to report? Boom, your case down the drain. Another myth, women out of spite are inclined to lie about sexual assault, because we do that all the time. And that was a myth that was sometimes taken as a reality. A woman can't be raped against her will. That was another myth. So you didn't resist. Why didn't you resist? Anybody being raped is going to resist. I mentioned from 10 years ago, a statement made by I think it was a senator, Republican Senator Todd Akins, who stated that if it is a legitimate rape, the woman will not get pregnant because our body automatically shuts down. So if you got pregnant and said you were raped as a result of it, well, that can't be, because your body's going to shut down. Rapists are strangers. And we know that's not true totally. Some cases, yes. And also, women say no, but you know what? They really mean yes. So those were some of the myths and the challenges that before the new laws came in 1982, that women had to deal with it. What happened with the changes, thank God, and a lot of these changes came about as a result of the work of Dawn, the Disabled Women's Network, and LEAF. They took sexual assault and made it just one big ball containing everything. Criminalization of sexual assault marriage came about, and then the consent of concept was clearly outlined. Definition nowadays in sexual assault in Canada, it's forced sexual activity. It's an attempt at forced sexual activity. So it is forced or an attempt. Now the force is the minute you're touched. It doesn't mean that someone has to throw you down on the floor and hold your hands down and sexually assault you. It's the fact that the touch becomes the assault, no matter how severe. Unwanted sexual grabbing, kissing, fondling. You're walking down a hallway, whatever, and someone comes up behind you and grabs your buttocks. That can be a sexual assault. You haven't given consent. All incidents of unwanted sexual assault, including sexual attacks and sexual touching. So it includes everything from someone coming up and giving you a kiss or grabbing your buttocks. That is a sexual assault to a rape. Okay. But again, any unwanted sexual contact, sexual assault can happen to anyone, regardless of gender, age, and cultural background. It includes, but it's not limited to, unwanted kissing, touching, penetration, attempted penetration can be committed by anyone, stranger, friend, partner, family member, or a person in position of authority. Now, consent in the law, it is the obligation of the accused to prove that the consent for sexual activity had been actively sought and obtained. Now think of that, actively sought and obtained. I used to do presentations, training presentations for university students. And an example I would give to outline this is, you're at a party, you're at a do, you meet someone, two people come together, maybe they've had a few drinks, but there's not necessarily inebriated as such. They start talking about things they have in common, and then all of a sudden, and I'm sure we've all experienced it, that you're going, you know what, I like that person, okay? I like that person. So maybe you have another couple of hours of conversation. One person asks the next person, hey, you want to go back to my apartment and have a glass of wine? Yeah, okay. So because that, whatever has happened that's gone between you, there might be that idea of that this evening might end in sex. Okay, it's an unwritten rule, right? It's an unwritten thing. You don't say, yeah, listen, you come back to my house for a glass of wine, but can we have sex when we get there? Well, no, because that's going to really screw up the moment, isn't it? It's going to ruin that feeling. So off you go. And sure enough, one thing leads to another. You're sitting on the couch and, arm around each other, whatever, and you end up in bed together. So I'll say to them, when at that point did you know, was there, the consent was actively sought and obtained? Well, you just know. Yeah, well, how do you know? Well, you don't want to break the moment, so when we take a look at that, obviously, a lot of evidence has to be brought forth, but that's basically what that says. Honest belief is no longer accepted. Well, for goodness sake, he or she came back to the apartment with me. Well, that's it. I took it for granted. The minute she steps over the door, he steps over the door, we're on. Well, no, not anymore. Consent not given if the person was intoxicated. Has anybody present at this presentation had sex with someone when they were intoxicated? Think about that. Basically, what that means is what the court would take a look is the state of the intoxication, but we don't have any guidelines in this law for how intoxicated you have to be. I guess if a complaint comes in, but I'll give you an example of one we had. University students out for the night after exams. One of the guys starts talking to one of the young women, etc. And she's getting pretty drunk. On her own, she's getting pretty drunk, but being the gentleman he is, he asks to drive her home, and she's met him for the first time, but he's one of the students, and off they go. Well, he doesn't go home. He goes to a local motel, and she is so drunk that he has to carry her in. And this motel, as sleazy as it was, had a camera. So we saw him coming in with her, and she can't even walk. So he just puts her down on the couch in the lobby, signs in, picks her up, and takes her to the room. Bottom line is, she wakes up the next morning, he's gone because he's not really a gentleman, and she has no idea where she is. So we have really strong evidence there because we've got the visual. But basically, if you're intoxicated, you can't give that. You can't give the consent. Diminished capacity, dealing with our clients who have mental disabilities, or aggressor was in a position of trust and authority. Is that someone has control over you? Is it a teacher? Is it your professor? Is it a doctor? I'll tell you one case we had with a police officer, which was interesting. He's out at night at a bar, picks up a woman, no problem. Everybody's okay. She comes home. She's not even intoxicated. When she walks into his apartment, in the dining room, he has his part of his uniform, his jacket on the chair, and he's got his guns and his handcuffs on the table. Do we have a person in authority there? Position of authority? Anyway, to make a long story short, it didn't go through the court, but it was a complaint put into police and went through a tribunal. And she felt that she had no choice when he started kissing her and that. So we're never too sure which way the courts will go. Next. No consent. If someone says in the midst of sexual activity, something that shows they are not consenting to an activity, and also to show they're not agreeing to continue that activity once they're in it. So if you have agreed to have sex with someone, you're in the midst of the activity in bed, and all of a sudden, your partner starts crying. Should that have been a sign to you that maybe this partner, there's a problem and the activity should stop, It doesn't mean that your partner was so enthralled with how great you were sexually that this is tears of joy. That's not what's happening here. So maybe the person turns their back, or maybe not even saying yes or no. There is some indication in the body language. Also, if the activity starts and you make a decision in the middle of it, no, I don't want to do this anymore, it has to stop immediately. Should it not on the part of the other person, that is a sexual assault. Someone is incapable of consenting to the activity because intoxicated, unconscious, asleep. Okay, being asleep is not saying yes. Being unconscious is not saying yes. And, mental disability as such. The consent is the result of another person abusing a position of trust, power, of authority. When we get sexual assaults by doctors, possibly when the women are on the examination. a psychiatrist taking advantage of the vulnerability, a teacher, a coach. Someone consents to sexual activity on behalf of someone else. Some of the cases I've had in the past is where a husband will say to someone else, listen, you know what, my wife, my girlfriend, she's crazy about you. Listen, go ahead. You want to get involved? Go ahead. You do what you have to do. You can't. No one else can give consent except you. Pressuring someone does not mean you have consent.
We're going to watch a quick video just to kind of tie this all in and for you to process sort of what you've heard and seen so far, okay? Just to make consent really clear.
Consent is a pretty simple concept. Say you want to make plans with a friend. Like invite them over to your house, take them to a movie, or go for ice cream. Before you can do this, you need to check to make sure they're cool with it, right? Same goes for sex. Before you start any sexual activity with someone, you need to make sure they understand and agree to participate in that sexual activity. Sexual activity includes kissing, touching, and sexual intercourse of any kind. So, what does consent look like? Consent is asking the other person for permission before you start any sexual activity. Consent is a verbal, voluntary yes, with everyone agreeing to the activity. And consent is done in person before the act and part of an ongoing conversation. Consent can also depend on how old you and the other person are. So take a moment to read this chart and make sure you understand the close-in age consent laws and how they apply to each group. It's also important to know if someone is drunk, high, or asleep, they cannot give consent. Pressuring someone into sexual activity does not mean you have consent. And not hearing a no does not mean you have consent. Be sure to pay attention to body language. Even if the other person verbally says yes, if their body language says no, you do not have consent. So how do you get consent? You ask for it. You say, "Is this okay with you?" Or, "Do you want to do this?" It might feel a bit awkward, but it's important to respect the other person's boundaries. Always ask for consent and always respect the answer. And how do you give consent? You clearly agree by saying yes, or using another positive statement like, "Sure, let's do this." So remember, yes means consent, and it's always okay to say no. You can also change your mind at any time. So even if you say yes, if at any point you start to feel uncomfortable, you can withdraw consent and say no. And no always means no. Sex without consent is sexual assault, and that is not cool. But communicating with the other person every time you take part in sexual activity and every time you change the type of sexual activity is cool. So always ask the question. Keep asking the question and respect the answer. And always make sure you and the other person both understand and agree to what you're doing. If you have any other questions about consent, be sure to talk to your parent, teacher, or a trusted adult.
Okay, the age of consent in Canada for anyone to agree to sexual activities is 16 years old. Okay? Exceptions to the rule of 16, and we'll go through those. Adults 18 years of age and older cannot have sexual relationships with people under the age of 16. Adults cannot have sexual relationships with a person aged 14 to 17 if they are in a position of trust or authority over a young person. A young person aged 14 or 15 can consent to sexual activity with someone less than 5 years. Okay, so a 14-year-old could consent to someone to have who's 18 years and 11 months. A 15-year-old can consent to have sex with someone that's 19 and 11 months. a young person aged 12 or 13 consents to sexual activity with someone less than 2 years older. So that would be a 13-year, 12 and 13, 13. These exceptions only apply if the person is not in a position of trust or authority and there's no exploitation. If you are under the age of 12, all young people under this age cannot give consent at all, even with someone who's close in age. In Canada, to sum it up, you have to be 16 years of age to be able to legally agree to sexual activity. This is the age of consent in our country. And this includes everything from kissing, sexual intercourse, but not any type of abuse or exploitation. There are some exceptions for youth under 16, but only if the youth are in peer groups or close in age. You have to be 18 years of age to legally agree to become involved in exploitation as such, prostitution, pornography, or when sexual activity happens in the relationship of authority, trust, or dependencies. For example, an 18-year-old can agree, if it's consensual, to have a relationship with their teacher, their professor, their coach, but you have to be 18. Take a look at the Criminal Code of 1892 in relation to women, victims, who have mental disabilities. It stated that unlawful carnal knowledge of any female imbecile, sorry, this part is hidden from me. Sorry about that. I just got this one. Insane or deaf or any dumb woman or girl under the circumstances that do not amount to rape, but which prove that the offender knew at the time of the offense that the woman belonged to one of the groups listed. In 1900, the Criminal Code maybe don't have to totally know, but had good reason to believe. If any of these cases were brought to court and the victims were any female idiot, imbecile, insane, or deaf, or any dumb woman, what would happen is juries were often advised and told it was a danger to convict based on the woman's testimony alone without cooperation. So needless to say, all these cases went south. Now, common law at that time held that an accused could be acquitted if the woman, the victim, had submitted out of an animal instinct caused by her idiotic state. Now, several of the courts at that time rejected common law, and they weren't motivated by the fact that that comment is insulting and discriminatory towards women. During those times, they felt that animal passion should be seen as proof of an inability to control the sexual impulses on part of the women, and therefore it was supported of a conviction. So, they didn't want anything to do with that. The Criminal Code in 1982, we had the offenses of rape and indecent assault replaced by a gender-neutral offense of sexual assault. Again, which requires application of force, and that's any physical contact without consent. And in 1992, they added that no consent is obtained where the complainant submits or does not resist because of the complainant's incapacity to consent. So the law before was if you had an incapacity to consent, you still had to resist. Now the law changed in 1992. In 1998, the Parliament enacted a new offense, and this was a result of Several of the agencies, the women agencies who fought long and hard, such as Leaf and Dawn, for women with mental disabilities, because of their vulnerability to physical and sexual abuse from caregivers and others in authority over them. And they wanted a law directed towards that. And they got this law in '98. It is sexual exploitation with a person with a disability where there is a relationship of authority or dependency between the accused and the person with the disability. And also they fought to have, and where the complainant does not consent, put in there, because they did not want women not to be able to have a sexual relationship with those possibly in authority if they develop a relationship or had some dependency on. So they did add does not consent. Trouble is, disability was not defined and consent has the same definitions for other sexual assault. However, if convicted, the maximum penalty is 5 years. Canada Evidence Act, Section 16, it's proposed if a proposed witness is a person of 14 years of age or older whose mental capacity is challenged, the court shall, before permitting the person to give evidence, conduct an inquiry to determine whether the person, the witness, understands the nature of an oath or a solemn affirmation, and whether the person is able to commute the evidence. However, if A does not apply, because they do not understand the oath or the affirmation, but they're able to communicate the evidence, they can testify on promising to tell the truth. And what the court also added as a result of the Supreme Court decision was that the defense could not challenge this last one on testifying on promising to tell the truth, where they could not ask questions like, what does truth mean, et cetera, et cetera. So on the bottom one, the testify on promising to tell the truth, if that route is taken, they can't be questioned on what the meanings are. One of the first cases that I came across was from, I believe it was 2012. And it involved a woman with an intellectual disability. And she was, I think, 18, 19, who reported to a teacher that her stepfather played games with her. And this included touching her genitalia and breast. And the evidence she revealed is that he also had a photograph of her bare-breasted, and she knew it was stored in a trunk along with some other pornographic material. However, the accused stated that that photograph was taken innocently. She did give a statement to the police at the preliminary inquiry. At trial, her competence to testify was successfully challenged by the defense. However, the court held that this witness was unable to adequately, sorry, I can't speak today, to explain the meaning of the abstract concepts like truth, lie, and promise when she was asked. So she was asked, what do you think about the truth? What's a promise? And if you tell big lies, will you go to jail? Her evidence was excluded. And the trial proceeded without her evidence, and the accused was acquitted. Well, what had happened in a result, the lower courts took a look at the Evidence Act, and they basically required mentally disabled witnesses to explain the meaning of abstract concepts like promise, truth, and falsehood when you know that wasn't required. And so they couldn't understand what that meant. The Supreme Court came back and said, no, people with mental disabilities are not required to meet a more onerous test than any other witnesses, because no other group of witnesses, not even convicted perjurers, were subjected to such a pre-testimonial inquiry. And what the court says, a witness can communicate her experiences, or she can describe what happened, or she can testify after saying that she promises to tell the truth. For the next slide, the second case was quite recent, 3 years ago, and it was a Slatter case. And what happened in this one is this young woman lived next door to neighbors who had a boarder, and the woman got involved with the male boarder who, over a period of 3 years ago, sexually assaulted her on many occasions, and she finally came forward. During there was a conviction initially, but it was overturned by the next court, the appellate court. And an expert witness was called, and what he was I think he was a forensic clinical psychiatrist, and basically he gave them sort of a contextualized version of her ability, or people's ability with mental problems to communicate evidence in court. However, he did state that people with intellectual disabilities are more suggestible to other people's ideas or reasoning than those without disabilities. And he stated that this victim, after he spoke with her, was in the 75th percentile for suggestibility compared to the general population. What the Supreme Court said is the appellate court overturned it because they ran with what the expert said. But what the Supreme Court basically said is, no, that they were wrong, that they looked at one part of the evidence, not all of it, and they overturned it, and the conviction was restored. And what this court came out with, what felt that the questioning of mentally disabled adults may require accommodation or individualized support, so that the evidence is best communicated to the court. And a statement they made, which I have to read you, which was Justice McLaughlin, states that the Supreme Court majority recognized that the testimony of women with mental disability promotes the truth-seeking function of the criminal process, particularly given the undeniable high rates of sexual assault and the interest of society in the reporting and prosecution of abuse. As the Supreme Court itself has said, excluding evidence of women with mental disability would effectively immunize the category of offenders from criminal responsibilities, with devastating harms to the abused women and to society as a whole. Next. The incapacity to consent is invoked infrequently by prosecutors in Canadian court. We spoke before about if you are incapacitated and mental disability supposedly falls within that range, you can, if under a voir dire or a court hearing, if they say, yes, you do not have the capacity to agree to sexual activity, then what happens is it's understood as a fixed status that disqualifies women from any sexual activity. Now, that does not mean they can't get involved in any other sexual activity. It does mean that once they have been qualified and they have that status, every sexual activity they've not given their consent. Incapacity is not defined in the statute, and it's left to judicial interpretation. The problem that we have with the court is capacity to consent now in Canada to sexual activity has been understood for all cases as an all or nothing phenomenon. Either a woman is capable of consenting to sex with anyone at any time, or she's never capable. And incapacity tends to be relied upon, from what we've seen in the courts, to a situation where the complainant has severe disabilities, and the defense is not going to challenge that because the disabilities are so severe that anybody can see this. Also, the case, sometimes I've seen where they've had advanced dementia or no awareness whatsoever of sexual activity. So the issue at trial doesn't come upon her capacity to consent. Basically, did the sexual activity take place? However, the court sometimes doesn't understand is that the complainant may understand that she's engaging in sexual activity, even with her mental disabilities, and may even say yes, but the sexual activity occurs most times in conditions of serious imbalance, of power in terms of mental ability and gender. An important point to remember is that a victim's or survivor's consent is not a defense in any human trafficking charge. No one has the legal right to consent to being exploited. And I think we all agree that persons with mental disabilities should not be presumptively excluded from sexual activity as a matter of basic rights.
And we absolutely know this because quality assurance measures and the ministry that we follow teaches rights and responsibilities and healthy relationships. And it's absolutely a human right for all of us. I think as we've talked, as Wendy's spoken, there's a lot to digest. And if there's any questions or frustrations or anything that we have felt through our process of our career and the work that we do in supporting individuals, I hope it provides some clarity today and what are the challenges that we're faced. And when I started doing sexual health over 20 years ago, I had to learn a lot about the legal system to understand, because it's incredibly frustrating. And when Wendy and I met and we went through what the law is and the explanation that you received today, it provided an incredible amount of understanding. And it allowed us to focus on what's the most important. What can we do? What can we control? What can we do? And so the concept of consent is incredible, because when you have diminished capacity, which is everyone we work with, they can't consent. If we prove that in court, they can never consent. They can never consent again and have a sexual healthy relationship. So you can see now why this is complicated. And working with victims of domestic human trafficking, or anyone who's wanting to have a relationship, why this conversation needs to be understood and happens. And as a result, they have a higher risk of being victims for things that we absolutely know. Things like the cost of social inclusion, right? Belief that the perpetrator is a boyfriend or girlfriend. And what I want to point out too is we are talking a lot about people identified as females and being the victims, but I want to very much say that people identified as males are also victims of trafficking and sexual assault. We see a higher rate of males in the LGBTQ+ community. We've had a few on our Montage supports from victims that are male. It absolutely does happen, but unfortunately we see a higher rate in the people identifying as female. That we have taken them on a date if they comply. Things like induced to engage in sexual activity in returns for small sums of money, drugs, or alcohol. During our time working with victims and throughout my career, I see this all the time, where individuals are paid with gift cards, money. They're introduced to alcohol, or they're given alcohol they've never had it before. They're given drugs, they've never had it before. And that allows induced engagement. And they may not even understand what has happened or what was going on, or may not even have a memory of it. Concerns about the consequences of refusing, even if the perpetrator has not made a quid pro quo. So quid pro quo, I just want to explain that to you, because it's not a language that I've used every day, but I've learned through this legal aspects of this, is that it's sexual harassment. What it means is sexual harassment arises when a subordinate suffers a tangible adverse action as a result of the subordinate's refusal to submit a higher up sexual demands. So simply put, we're talking about the people who may be the pimp, the perpetrator, who are making demands. okay? If you refuse it, there might be consequences, right? Whether you refuse money, food, where they threaten your family, they know where you live, your friends, that sort of situation. That's consequences. And we've seen that, absolutely. For all of us who work in this field with individuals with intellectual developmental disabilities, we know this, but I just want to reinforce what we're up against always, okay? Greater risk of sexual assault and violence. We know absolutely the people who identify as women in our sector are at a greater risk. And usually it's to the male community. Individuals who identify as male, they're at greater risk. Are often infantilized and disbelieved once they report. Are sexually assaulted 3 times the rate of a neurotypical person. Not seen as credible witnesses or victims. Undergo significant levels of isolation, self-doubt, reluctance to report or seek support. They absolutely wouldn't even know, if they've never had a relationship, a healthy relationship, wouldn't even know where to go or how to report, or even that they should. Additional barriers have been created for women with IDD due to the lack of sexual health training. We have none. Knowledge of services support with regards to sexual assault offenses and investigations in relation to individuals with IDD. We are now still struggling with this, and we constantly struggle with this, which is why we're here today to talk about this. What I just want to say and add to what's important is, what is the outcome to this presentation? What are your thoughts and processes? There's a lot to take in here. It's a lot of frustration, anger. And what I've learned, and what we've all learned through the process of supporting individuals, is we have to focus on the people we're supporting, and not get bogged down by why the law isn't, acceptable, why it's not equitable, there's no rights. We can't focus on those things because we can't change those things right now. But what we can do is work with the individuals and empower them. We need to provide basic sexual health training. We need to teach the concepts of what a healthy relationship is. And we all, as professionals, need to know where we go for services and supports if someone has experienced a sexual assault, and who can investigate this process and who can support the process. And what I'm thrilled to say today, and have been through this process, and I'm so grateful for the role and the work that Montage Support Services done with working with victims of domestic human trafficking and IDD, and working with Wendy and everyone else, is that we have spent a lot of time at the Toronto Police Headquarters over the last year. And I'm thrilled to say that we have aligned some really great contacts with Victim Services Toronto, who will be actually speaking in September, the Sexual Assault Unit in Toronto, and the Domestic Human Trafficking Unit at Toronto. And we have shared, Wendy and I have shared sort of case study stories, scenarios that we've been dealing with just within the short year plus with the domestic human trafficking team and throughout, around what unique supports we need, not even as our small team, but as a sector. And so what we're asking today, or what we're letting you know today, is that we love to triage those conversations, okay? Wendy and I are available to triage those conversations and then provide you with a line of communication to those particular units so that we can build a greater understanding and a stronger relationship with these 3 teams. They're committed to do that with us. We have to be patient with the process, but I'm excited to announce that we have this opportunity because Wendy and I have learned, and our team has learned, that there is no data, there's no information in regards to our community and our population and the supports they receive and how many people have gone to the police, are presumed to be having a developmental disability or not. So this is where we've got to, and we're thrilled to say, share that with you today and process that information. And so what I'd like to do at this point is just turn off the recording.
Deanna, can I add one more thing?
Yeah.
Sorry.
Yeah.
Okay. In relation what Deanna has said, I found during the research I was doing and the human traffic presentations we did and talking and receiving information from different of the support workers and agencies is that there appears sometimes to be that fear of contacting the police. And it's obviously the fear that your victim is going to be dragged into court, or his or her name is going to be on a police report, etc. Please realize that the police are there to discuss the case with you. Information that you give them, even though the victim may not want to go to court, wouldn't be capable of going to court, whatever, the information is so valuable because you may be sitting with information from that victim of who the person is, of what happened, what the human trafficking situation, and if this individual has sexually assaulted your client, that is not the first and only one. So the opportunity to at least give the police the information anonymously as such, because you don't give the victim's name, it is an amazing source. We may find out that that person has been involved with, many other people. So don't hesitate to do that. And some of the feedback I got is that some of the agencies are very hesitant about calling the police, and I understand why, or maybe supervisory situations that you're not allowed to do that. But it might be something to speak about, especially if you know something is happening and your hands are tied and you feel the police should be involved. We just want to tell you that there's a way to do it where there's not going to be a feedback, sort of off the record to begin with.
Yeah, in the languages, and I believe Wendy and I've talked, it's create an occurrence, right? So like we create an occurrence, something has happened, they document it. You might know who the person is or not, but it's in the books, right? It's amazing how many people are reoffenders. And it may not be, you might not be the case, but they might have enough information to know about him and hear him or her in the other ways, right? So it's a way to advocate and create relationships and empower people to know that there is a system that will support them, and that we just have to go directly to the source, per se, and find that information and get that support.